Every day in the USA, people find themselves in court.
All right, Mr. Campbell, I'm assuming ready on Mr. Goheen Rango.
That's correct, Your Honor.
Morning, Mr. Goheen Rango.
Mr. Judge Wheeler.
Yep. Go ahead,
And
Mr. Campbell.
everybody.
I don't, I'm sure Your Honor may recall some of the discussion in last hearings regards to the defense's motion for counsel's request to withdraw. I've had opportunity to speak with Mr. Goheen Ringo in custody since that last hearing last week. I still have a good faith basis to indicate there is not a pathway moving forward to repair our relationship, in my opinion. The client, I believe, over my objection, wants to make an oral record of his own. So I'll defer to him if he's going to do that, but did provide him an opportunity for me to provide to the court his presentation to protect his right to remain silent. But ultimately, I believe that there is the perception of an unwaivable conflict based off of the client's statement that I waived his attorney-client privilege, damaging his case. And even if I disagree with that assessment, there are certain waivable conflicts that I am not capable of overcoming these conflicts with the client. In my opinion, I don't believe the client is able of overcoming my concerns. And so those are the grounds upon which I'm seeking to withdraw. I have done a little bit of research on the case law surrounding these types of circumstances where a client is objecting potentially to counsel's withdrawal. I have not. I could, if Your Honor has concerns about that, I can put those into writing or recall the matter. But ultimately, I believe that at this point, my counsel of Mr. Goheen Ringo should be ordered withdrawn, and counsel should be substituted in for his trial in these matters.
Let me ask you, I am going to allow Mr. Campbell to withdraw. Mr. Goheen Rango, I was present in court when you elicited that attorney-client privilege had been violated, and that you felt prejudiced by that. I don't think we can walk that back. That was on the record and part of the court proceedings several weeks ago. So I'm going to grant Mr. Campbell's motion to withdraw. My question, Mr. Goheen Rango, because I know it had been floated to the court two different ways. One way was that you were choosing to represent yourself now. The second would be if you are asking the court to assign you a new attorney. So my first question is, are you planning to represent yourself at this stage, or are you asking the court to appoint you another attorney?
That's a really good question. That kind of cuts me off from what my train of thought was going. I had a question that maybe should go before that question, but I was just wondering, is that all that's necessary for a judge to remove an attorney? Is that just whether it's true or not, someone who's been accused of a crime can just simply mention that he believes that an attorney has violated his attorney-client privilege, and that's all it takes to have that attorney removed?
No, because even prior to that time, you were expressing to the court that very day that you believed that Mr. Campbell was not working in your best interest.
Okay.
It seems that apparently that morning there had been some conflict between you and Mr. Campbell of some nature prior to the court proceeding. Again, I'm not privy to that. It sounded like both people.
There was no conflict. There was no conflict.
But again, after that proceeding, after Mr. Campbell's statements on the record, your statements on the record were that your attorney-client privilege had been violated, which is not revocable. I can't ask why it was violated because, again, that's attorney-client privilege. So you invoked that in open court after it was already the perception of the court that the relationship between you and Mr. Campbell had broken down. So again,
Okay.
the court can withdraw an attorney based on the intractability of the relationship between the defense attorney and the defendant. But I think
Okay.
when we add on top of that, also statements that attorney-client privilege had been violated and there was an intractable relationship at that stage, I think that seals the deal. So
Okay. I didn't know. I definitely wouldn't have said those things had I known that this would be the consequence. My concern with it, if I can recollect where my train of thought was that day, was I thought he had mentioned few details that I didn't want mentioned on the court. I think if I went back,
And
I
again,
believe he did.
we're not gonna go into that today, because if indeed those details were subject to attorney-client privilege, we're not gonna restate them and point out to them which ones you thought they were. Because again, you'd be invoking things that you said were privileged to the court on the record in open court.
Okay.
So again, where we are going with this is a very simple question. Are you
Yeah.
asking to represent yourself moving forward, or are you asking the court to assign you another attorney?
I think I would like to be assigned an attorney. Now hold on. Actually, if I represent myself, will I have facilities to be able to do that while I'm in custody here, or can I be sent a packet on instruction how to you know how to do this? Because I don't know, might be interested in that.
The court cannot provide you materials in good conscience that are not already available at the Clark County Jail and what is provided there. That would be the court inserting itself into your defense, and the court is an impartial fact finder. The court's responsibility is not to assist people in self-representation. So
Okay.
the issue that this court has is there's a conflict with every existing attorney that this court has with you, or a conflict based on we don't have anyone left. So the court
only
is going to have to explore in the next week whether we can find an attorney in Clark County that will accept representation. I'm not going to
Okay.
go any further than that, but that's the status of the court. So I think we're going to
Okay.
have to set this matter over 1 week, and the court will have to reach out and determine if we can find counsel. Yes, Mr. Goheen.
Is there there's a few attorneys that my mom's been supporting me throughout all this. She's been in contact with. Would it be possible to have them apply personally, or is it just only on the court's behalf to go seek one out? In other words, can one volunteer, one that we've been talking with, or?
Would have to be a licensed attorney
Of course, yeah.
in the state of Washington that has some background in criminal defense. I'm certainly not
Okay.
going to have a tax attorney in here trying to navigate a jury trial.
Yeah.
But if there is an attorney that you are aware of that is wanting to accept your defense or availability
Yes,
in court, that's where we'll go. But
okay. So, and then they just have to show up, or on the Zoom or in person on the next setting.
they would have to contact the court prior to the next setting. The court would have
Oh.
to vet whomever this is, vet
Yeah.
their availability and so forth. So
Okay.
it can't be a surprise guest behind door number 3. It has to be someone who has contacted the court. We're going to see again next Thursday in 7 days. And we'll see what we can do. Okay.
And Your Honor,
All right. Thank you, Your Honor.
I just wanted to check our speedy. I don't have the commencement right in front of me.
I want to say is April 17th.
Okay.
So we are going to be 30 days elapsed.
Great,
Mr.
okay.
Goheen Rango is not being held on these matters. Let me look though. I remember that the waiver, let's see.
Have it entered.
April 17th,
Okay.
2025, entered February 20th, 2025.
Thank
So
you.
we
Okay.
are 32 days elapsed next Thursday, the 15th. Ms. Carmi, do you have an objection of this matter coming back next week? I know that you are not personally going to be present for, I suppose, the assignment of counsel. My recollection, if we have withdrawal, is that speedy trial will recommence with the assigning of a new attorney.
Yeah, I have no objection to this being heard next week.
Okay. All right, Mr. Goheen Rango, we are going to see you next week, sir, and we will work on getting you counsel. Thank you.
Thank you, Your Honor.
Yep.
Thank you, Ms. Carmi.
Thank you.
Thank you, Brandon, if you're still there.
All right,
Judge.
Mr. Campbell, ready on Ms. Pickett-Kennick?
Yes, Your Honor.
All right. Ms. Pickett-Kennick, can you hear the court, ma'am?
Yes, I fired my attorney last week, so I don't even know why he's over here trying to represent me. And that's why I have a warrant, is because he fails to understand that I fired him and asked for a continuance.
Understood.
His office is not representing me to the best of their ability, and that is why I fired him.
Okay, go ahead, Mr. Campbell.
Your Honor, the client is indicating that she would like to terminate my services. I have indicated to her that I think it's unlikely that Your Honor will rule on that motion until the 1077 evaluation is completed in this case. This matter was last in court on April 24th. The client made an appearance on April 25th in Superior Court and was sentenced on a Superior Court matter. So that is one factor I would note for the court's consideration. The client had an appearance the following week scheduled in our court. I'm not saying she didn't appear, but a warrant was issued. Now she makes her way before Your Honor. I believe Mr. Schoonover has indicated that she is amenable to potentially out of custody restoration. But we need to get an evaluation completed. I think.
Your Honor, I spoke with Brian the day I left custody, and I actually had an appointment, then got arrested. So my attorney is not doing his job at all. He's sitting there fumbling with his words.
I haven't received further information from Mr. Schoonover. What she's saying may be completely accurate, that she had a future appointment for an out of custody evaluation. Those usually take some months, Judge. So I'm not sure.
Your Honor,
Yes.
Mr. Campbell needs to actually change his website because he doesn't help victims, he causes victims. And I really would like him off my case, because back in October of last year, he gave me paperwork on
Ma'am, I
the
wouldn't
trespass.
recommend speaking on
No,
the docket any
I
further.
recommend you stop speaking for me, because you're not helping my case. Your Honor, back in October of last year, Mr. Campbell handed me paperwork on the trespass. It is a business trespass, not my son's address. This all could have been resolved back in October of last year.
So Ms. Pickett-Kennick, do you know the next steps in regards to the out of custody evaluation then?
Yes, I talked to Brian's my son. I talked to Brian the day that I got released. Your Honor, the things that are going on out here in custody are just, it's guerrilla warfare, and I'm not playing anymore. It's not, anyways, I just have to pick up the phone, call Brian, and he's gonna do it. He came in and did a competency to see if I was competent the day I got released. And I just have to call him and make the appointment. It's not gonna take months. It's only gonna take days for me to get in there. And I also have wraparound services to get into housing through CMAR. All that has been set up. If everything would stop being meddling with, I could actually get my life on track. Your Honor, I am trying, but there's guerrilla warfare going on out here with these patriots, and I'm not playing. I have mental problems. I have anxiety, PTSD, and bipolar, yes, and they're all being treated and have been for quite some time. I went through EMDR 3 times. I went through counseling 3 years. I am sound mind and cognitive. I just need people to let me do me and let me get with everything that has been put in place to actually get my life in place. Your Honor, and I really want Campbell off of my case. He is not, go look at his website. That is so not even, that's not right. You're causing victims, Brandon. You're causing victims.
Ms. Pickett-Kennick, we are going to release you on your hold today. We are going to schedule a future court date for you, ma'am, on June 26th, 2025 at 10 a.m. We're going to get you some paperwork in regards to that court date over at the jail. I did sign off on the competency evaluation order, so hopefully we get that taken care of. It sounds like you know the next steps on that. And
Yes,
that
Your Honor, I
concludes
do.
the hearing. Thank you, ma'am.
Thank
Judge,
you,
if
Your
I could
Honor.
just briefly give the client some information. Ms. Pickett-Kennick, stay in contact with Brian Schoonover. He is not the
Talk to me.
evaluator.
Do not talk to me, Brian.
It may be beneficial for the client to get new counsel, Your Honor. She has to be able to participate and communicate with counsel in order to be able to facilitate the evaluation, because the out-of-custody evaluator will email myself and possibly Brian Schoonover, and then Ms. Pickett-Kennick would need to cooperate with counsel in scheduling that evaluation. And so I don't know what to say.
I don't either. Ms. Pickett-Kennick, can you at least work with Mr. Campbell to get the evaluation scheduled, ma'am?
Yes, I can work with him to at least do that, Your Honor. I can at least do that. Or his secretary, yes, Your Honor, I can.
Okay, let's just leave it at that for now. And if we still have conflict after the evaluation, we can then get you a new attorney. Okay, ma'am?
All right, thank you so much, Your Honor.
Thank you. All right, I got Mr. Wallace and Mr. Sowards. Mr. Wallace, do you have an in custody person?
I do, Your Honor. Paul Cole.
Okay. All right, Mr. Cole, can you hear the court, sir?
Yes, sir, I can, Your Honor.
Thank you. Can I have you state your name and date of birth, please, for the record?
9/29/79, Paul Lee Cole Wagner.
So, Mr. Cole, it sounds like last time that you were in court, you may have made some inappropriate gestures when you were on camera. So I'm going to give you an opportunity if you'd like to apologize to the court or
Yes,
anyone
sir.
viewing that
Yes, sir,
video, please.
Yes, sir, I apologize very, very much so on that.
It's not how we conduct ourselves in court, sir. Whether you hear something that you want to hear or something you don't want to hear, you're an adult and you need to act like an adult. Do you understand?
I thought it was officer. I am
No.
so sorry. I am
Okay.
so sorry.
Go
I
ahead, Mr. Cole.
apologize, Your Honor.
Thank you, Your Honor. I believe today we're in front of the court on 3 cases, the 1A case, the 2A
Do you have the
case.
court files?
I do, Your Honor. Should I hand those forward?
Yeah, if you don't
Sorry
mind.
about that.
That's all right. Yeah, sure. Thank you. All right, go ahead.
The 1A case, 2A case, these are both PV matters, and then we have the pending alleged domestic violence no contact order violation. Your Honor, I believe dealt with the probation violations 1 week ago.
I did.
And so I don't know that there are any issues to resolve with regard to those 2 cases. On the 4A case, I've spoken to the prosecution. I believe we have a joint recommendation for the defendant to be released to intensive release while we sort of sort out negotiations on the matter. My understanding is that Mr. Cole has a DOC hold, or at least he believes strongly that he does, and that it will last approximately 14 days. And so at least for those 2 weeks, it sounds unlikely that Mr. Cole would be able to check in person. But after that, I think it certainly would be. And that was after that, hopefully give him the opportunity to provide the copies of the evaluations for mental health and domestic violence to the municipal court here. But I am requesting that the court set this matter over to June 12th, 2025, for us to address this matter then while client's on intensive release.
Ms. Carmi?
That is correct, Your Honor. I think defense has given us today some information that may call into question proper service of the underlying NCO. We need time to further investigate that, talk to the victim. And so we think that this strikes a balance of releasing him, allowing him to take care of DOC. Frankly, I don't know how the court can monitor him being placed on intensive pretrial, but our request is within 24 hours of being released from DOC that he report to Clark County Pretrial Services and then come back at that June date.
All right, Mr. Cole, it seems that the city and your attorney are gonna bet that you come back. Unfortunately, your track record is not the greatest for doing so, but we will release the battleground holds today. We will schedule.
Thank you, sir. Where do I check in? Do I go to the actual Clark County here, the actual downtown, or to you guys in Battleground because of that?
You're on
the check-in?
intensive. hold on. You're on intensive pretrial release with Clark County pretrial release. So you're gonna, when you were released from your DOC hold, you're gonna check in with Clark County pretrial release. They're gonna keep you at the intensive level to monitor you, including some in-person check-ins. So your information for that is on the paperwork you're gonna be getting when you are concluded with your hearing today.
Thank you, sir. I'm so sorry, Your Honor.
It's all right.
Well, I do apologize. My actions were not appropriate.
Right, release conditions violate no laws, appear at all mandatory court dates, notify the court of any change of address or phone number. Mr. Cole will be released on this matter on intensive pretrial release. How we're gonna do it, because I have 3 cause numbers on here and it's gonna look like they're all on intensive. I want just the new law charge. So I want 4A0299226 to be the charge that's on intensive. The other 2 probation cases are gonna be on recognizance. But I'm not gonna mark both boxes because it's gonna be confusing. Does that make sense? Okay. All right, Mr. Cole, we'll see you back here June 12th at 10 o'clock in the morning, sir.
Thank you, guys. Thank you, prosecutor. Thank you, Kevin. I thank you, Judge. I appreciate everything, buddy.